The Federal Reserve Act, Part 1. 63rd Congress of the United States of America, at the second session, begun and held at the city of Washington on Monday, the first day of December, 1913. An act to provide for the establishment of Federal Reserve banks, to furnish an elastic currency, to afford means of rediscounting commercial paper, to establish a more effective supervision of banking in the United States, and for other purposes. Being enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that the short title of this act shall be the, quote, Federal Reserve Act, unquote. Wherever the word, quote, bank, unquote, is used in this act, the word shall be held to include state bank, banking association, and trust company, except where national banks or Federal Reserve banks are specifically referred to. The terms, quote, national bank, unquote, and, quote, national banking association, unquote, used in this act shall be held to be synonymous and interchangeable. The term, quote, member bank, unquote, shall be held to mean any national bank, state bank, or trust company which has become a member of one of the reserve banks created by this act. The term, quote, board, unquote, shall be held to mean Federal Reserve Board. The term, quote, district, unquote, shall be held to mean Federal Reserve District. The term, quote, Reserve Bank, unquote, shall be held on to mean Federal Reserve Bank. Federal Reserve Districts. Section 2. As soon as practicable, the Secretary of the Treasury, the Secretary of Agriculture, and the Comptroller of the Currency acting as, quote, the Reserve Bank Organization Committee, unquote, shall designate not less than 8, nor more than 12 cities to be known as Federal Reserve cities, and shall divide the continental United States, excluding Alaska, into districts, each district to contain only one of such Federal Reserve cities. The determination of said organization committee shall not be subject to review except by Federal Reserve Board when organized, provided that the district shall be apportioned with due regard to the convenience and customary course of business, and shall not necessarily be conterminous with any state or states. The districts thus created may be readjusted, and new districts may from time to time be created by the Federal Reserve Board, not to exceed 12 in all. Such districts shall be known as Federal Reserve Districts, and may be designated by number. A majority of the Organization Committee shall constitute a quorum with authority to act. Said Organization Committee shall be authorized to employ counsel and expert aid, to take testimony, to send for persons and papers, to administer oaths, and to make such investigation as may be deemed necessary by the said committee in determining the reserve districts, and in designating the cities within such districts where such Federal Reserve banks shall be severally located. The said committee shall supervise the organization in each of the cities designated of a Federal Reserve Bank, which shall include in its title the name of the city in which it is situated, as, quote, Federal Reserve Bank of Chicago, unquote. Under regulations to be prescribed by the Organization Committee, every national banking association in the United States is hereby required, and every eligible bank in the United States and every trust company within the District of Columbia is hereby authorized to signify in writing, within 60 days after the passage of this act, its acceptance of the terms and provisions hereof. When the Organization Committee shall have designated the cities in which Federal Reserve banks are to be organized, and fixed the geographical limits of the Federal Reserve districts, every national banking association within the district shall be required within 30 days after notice from the Organization Committee to subscribe to the capital stock of such Federal Reserve Bank in a sum equal to 6 per centum of the paid-up capital stock and surplus of such bank, 1/6 within 3 months, and 1/6 within 6 months thereafter, and the remainder of the subscription, or any part thereof, shall be subject to call when deemed necessary by the Federal Reserve Board. Said payments to be in gold or gold certificates. The shareholders of every Federal Reserve Bank shall be held individually responsible, equally and ratably, and not one for another, for all contracts, debts, and engagements of such bank to the extent of the amount of their subscriptions to such stock at the par value thereof, in addition to the amount subscribed, whether such subscriptions have been paid up in whole or in part, under the provisions of this Act. Any national bank failing to signify its acceptance of the terms of this Act within the 60 days aforesaid shall cease to act as a reserve agent, upon 30 days' notice, to be given within the discretion of the said Organization Committee or of the Federal Reserve Board. Should any national banking association in the United States now organized fail within 1 year after the passage of this Act to become a member bank, or fail to comply with any of the provisions of this Act applicable thereto, all of the rights, privileges, and franchises of such association granted to it under the National Banking Act, or under the provisions of this Act, shall be thereby forfeited. Any noncompliance with or violation of this Act shall, however, be determined and adjudged by any court of the United States of competent jurisdiction in a suit brought for that purpose in the district or territory in which such bank is located, under direction of the Federal Reserve Board by the Comptroller of Currency in his own name, before the association shall be declared dissolved. In cases of such noncompliance or violation, other than the failure to become a member bank under the provisions of this Act, every director who participated in or assented to the same shall be held liable in his personal or individual capacity for all damages which said bank, its shareholders, or any other person shall have sustained in consequence of such violation. Such dissolution shall not take away or impair any remedy against such corporation, its stockholders or officers, for any liability or penalty which shall have been previously incurred. Should the subscriptions by banks to the stock of said Federal Reserve banks, or any one or more of them be, in the judgment of the Organization Committee, insufficient to provide the amount of capital required therefor, then and in that event the said Organization Committee may, under conditions and regulations to be prescribed by it, offer to public subscription at par such an amount of stock in said Federal Reserve banks, or any one or more of them, as said committee shall determine, subject to the same conditions as to payment and stock liability as provided for member banks. No individual, copartnership, or corporation other than a member bank of its district shall be permitted to subscribe for or to hold at any time more than $25,000 par value of stock in any Federal Reserve Bank. Such stock shall be known as public stock and may be transferred on the books of the Federal Reserve Bank by the chairman of the board of directors of such bank. Should the total subscriptions by banks and the public to the stock of said Federal Reserve banks, or any one or more of them, be, in the judgment of the Organization Committee, insufficient to provide the amount of capital required therefor, then and in that event the said Organization Committee shall allot to the United States such an amount of said stock as said committee shall determine. Said United States stock shall be paid for at par out of any money in the Treasury not otherwise appropriated, and shall be held by the Secretary of the Treasury and disposed of for the benefit of the United States in such manner, at such time, and at such price, not less than par, as the Secretary of Treasury shall determine. Stock not held by member banks shall not be entitled to voting power. The Federal Reserve Board is hereby empowered to adopt and promulgate rules and regulations governing the transfer of said stock. No Federal Reserve Bank shall commence business with a subscribed capital less than $4 million. The organization of reserve districts and Federal Reserve cities shall not be construed as changing the present status of reserve cities and Central Reserve cities, except in so far as this Act changes the amount of reserves that may be carried with approved reserve agents located therein. The Organization Committee shall have the power to appoint such assistants and incur such expenses in carrying out the provisions of this Act as it shall deem necessary, and such expenses shall be payable by the Treasurer of the United States upon voucher approved by the Secretary of the Treasury, and the sum of $100,000, or so much therefore as may be necessary, is hereby appropriated out of the moneys in the Treasury not otherwise appropriated for the payment of such expenses. Federal Reserve Banks. Section 4. When the Organization Committee shall have established Federal Reserve Districts as provided in Section 2 of this Act, a certificate shall be filed with the Comptroller of the Currency showing the geographical limits of such districts, and the Federal Reserve City designated in each of such districts. The Comptroller of the Currency shall thereupon cause to be forwarded to each national bank located in each district, and to such other banks declared to be eligible by the Organization Committee, which may apply therefor, an application blank and form to be approved by the Organization Committee, which blank shall contain a resolution to be adopted by the Board of Directors of each bank executing such application, authorizing a subscription to the capital stock of the Federal Reserve Bank organizing in that district in accordance with provisions of this Act. When the minimum amount of capital stock prescribed by this Act for the organization of any Federal Reserve Bank shall have been subscribed and allotted, the Organization Committee shall designate any 5 banks of those whose application have been received to execute a certificate of organization, and thereupon the banks so designate shall, under their seals, make an organization certificate which shall specifically state the name of such Federal Reserve Bank, the territorial extent of the district over which the operations of such Federal Reserve Bank are to be carried on, the city and state in which said bank is to be located, the amount of capital stock and the number of shares into which the same is divided, the name and place of doing business of each bank executing such certificate, and of all banks which have subscribed to the capital stock of such Federal Reserve Bank, and the number of shares subscribed by each, and the fact that the certificate is made to enable those banks executing same, and all banks which have subscribed or may thereafter subscribe to the capital stock of such Federal Reserve Bank, to avail themselves of the advantage of this Act. The said organization certificate shall be acknowledged before a judge of some court of record or notary public, and shall be, together with acknowledgment therefor, authenticated by the seal of such court or notary, transmitted to the Comptroller of the Currency, who shall file, record, and carefully preserve the same in his office. Upon the filing of such certificate with the Comptroller of the Currency as aforesaid, the said Federal Reserve Bank shall become a body corporate, and as such, and in the name designated in such organization certificate, shall have power: first, to adopt and use a corporate seal; second, to have a succession for a period of 20 years from its organization unless it is sooner dissolved by an act of Congress, or unless its franchise becomes forfeited by some violation of law; third, to make contracts; fourth, to sue and be sued, complain, and defend in any court of law or equity; fifth, to appoint by its Board of Directors such officers and employees as are not otherwise provided for in this Act, to define their duties, require bonds of them, and fix the penalty thereof, and to dismiss at pleasure such officers or employees; sixth, to prescribe by its Board of Directors bylaws not inconsistent with law, regulating the manner in which its general business may be conducted, and the privileges granted to it by law may be exercised and enjoyed; seventh, to exercise by its Board of Directors, or duly authorized officers or agents, all powers specifically granted by the provisions of this Act, and such incidental powers as shall be necessary to carry on the business of banking within the limitations prescribed by this Act. Eighth, upon deposit by the Treasurer of the United States of any bonds of the United States, in the manner provided by existing law relating to national banks, to receive from the Comptroller of Currency circulating notes in blank, registered and countersigned as provided by law, equal in amount to the par value of the bonds so deposited, such notes to be issued under the same conditions and provisions of law as relate to the issues of circulating notes of national banks secured by bonds of the United States, bearing the circulating privilege, except that the issue of such notes shall not be limited to the capital stock of such Federal Reserve Bank. But no Federal Reserve Bank shall transact any business except such as is incidental and necessary preliminary to its organization until it has been authorized by the Comptroller of Currency to commence business under the provisions of this Act. Every Federal Reserve Bank shall be conducted under the supervision and control of a Board of Directors. The Board of Directors shall perform the duties usually appertaining to the office of Directors of banking associations and all such duties as are prescribed by law. Said Board shall administer the affairs of said bank fairly and impartially and without discrimination in favor of or against any member bank or banks, and shall, subject to the provisions of law and the orders of the Federal Reserve Board, extend to each member bank such discounts, advancements, and accommodations as may be safely and reasonably made, with due regard for the claims and demands of other member banks. Such Board of Directors shall be selected as hereinafter specified and shall consist of 9 members, holding office for 3 years, and divided into 3 classes, designated as Classes A, B, and C. Class A shall consist of 3 members, who shall be chosen by and be representative of the stockholding banks. Class B shall consist of 3 members, who at the time of their election shall be actively engaged in their district in commerce, agriculture, or some other industrial pursuit. Class C shall consist of 3 members, who shall be designated by the Federal Reserve Board, when the necessary subscriptions to the capital stock have been obtained for the organization of any Federal Reserve Bank. The Federal Reserve Board shall appoint the Class C directors, and shall designate one of such directors as chairman of the board to be selected. Pending the designation of such chairman, the Organization Committee shall exercise the powers and duties appertaining to the office of chairman in the organization of such Federal Reserve Bank. No senator or representative in Congress shall be a member of the Federal Reserve Board, or an officer or a director of a Federal Reserve Bank. No director of Class B shall be an officer, director, or employee of any bank. No director of Class C shall be an officer, director, employee, or stockholder of any bank. Directors of Class A and Class B shall be chosen in the following manner. The chairman of the Board of Directors of the Federal Reserve Bank of the district in which the bank is situated, or, pending the appointment of such chairman, the Organization Committee shall classify the member banks of the district into 3 general groups or divisions. Each group shall contain as nearly as may be 1/3 of the aggregated number of the member banks of the district, and shall consist, as nearly as may be, of banks of similar capitalization. The group shall be designated by number by the chairman. At a regularly called meeting of the Board of Directors of each member bank in the district, it shall be elect by ballot a district reserve elector, and shall certify his name to the chairman of the Board of Directors of the Federal Reserve Bank of the district. At a regularly called meeting of the Board of Directors of each member bank in the district, it shall be elect by ballot a district reserve elector, and shall certify his name to the chairman of the Board of Directors of the Federal Reserve Bank of the district. The chairman shall make a list of the district reserve electors thus named by banks in each of the aforesaid 3 groups, and shall transmit one list to each elector in each group. Each member bank shall be permitted to nominate to the chairman 1 candidate for director of Class A and 1 candidate for director of Class B. The candidates so nominated shall be listed by the chairman, indicating by whom nominated, and a copy of said list shall, within 15 days after its completion, be furnished by the chairman to each elector. Every elector shall, within 15 days after the receipt of said list, certify to the chairman his first, second, and other choices of a director of Class A and Class B, respectively under a preferential ballot, on a form furnished by the chairman of the Board of Directors of the Federal Reserve Bank of the district. Each elector shall make a cross opposite the name of the first, second, and other choices for a director of Class A and for a director of Class B, but shall not vote more than one choice for any one candidate. Any candidate having a majority of all votes cast in the column of first choices shall be declared elected. If no candidate have a majority of all the votes in the first column, then there shall be added together the votes cast by the electors for such candidates in the second column, and the votes cast for the several candidates in the first column. If any candidate then have a majority of the electors voting, by adding together the first and second choices, he shall be declared elected. If no candidate have a majority of electors voting when the first and second choices shall have been added, then the votes cast in the third column for other choices shall be added together in like manner, and the candidate then having the highest number of votes shall be declared elected. An immediate report of election shall be declared. Class C directors shall be appointed by the Federal Reserve Board. They shall have been for at least 2 years residents of the district for which they are appointed, one of whom shall be designated by said board as chairman of the Board of Directors of the Federal Reserve Bank and as, quote, Federal Reserve Agent, unquote. He shall be a person of tested banking experience, and in addition to his duties as chairman of the Board of Directors of the Federal Reserve Bank, he shall be required to maintain under regulations to be established by the Federal Reserve Board. He shall make regular reports to the Federal Reserve Board, and shall act as its official representative for the performance of the functions conferred upon it by this Act. He shall receive an annual compensation to be fixed by the Federal Reserve Board and paid monthly by the Federal Reserve Bank, to which he is designated. One of the directors of Class C, who shall be a person of tested banking experience, shall be appointed by the Federal Reserve Board as Deputy Chairman and Deputy Federal Reserve Agent to exercise the powers of the Chairman of the Board and Federal Reserve Agent in case of absence or disability of his principal. Directors of Federal Reserve Bank shall receive, in addition to any compensation otherwise provided, a reasonable allowance for necessary expenses in attending meetings of their respective boards, which amount shall be paid by the respective Federal Reserve Banks. Any compensation that may be provided by boards of directors of Federal Reserve Banks for directors, officers, or employees shall be subject to the approval of the Federal Reserve Board. The Reserve Bank Organization Committee may, in organizing Federal Reserve banks, call such meetings of bank directors in the several districts as may be necessary to carry out the purpose of this Act, and may exercise the functions herein conferred upon the chairman of the Board of Directors of each Federal Reserve Bank, pending the complete organization of such bank. At the first meeting of the full Board of Directors of each Federal Reserve Bank, it shall be the duty of the directors of classes A, B, and C, respectively, to designate one of the members of each class whose term of office shall expire in 1 year, from the 1st of January, nearest the date of such meeting, one whose term of office shall expire at the end of 2 years from said date, and whose term of office shall expire at the end of 3 years from said date. Thereafter, every director of a Federal Reserve Bank, chosen as hereinbefore provided, shall hold office for a term of 3 years. Vacancies that may occur in the several classes of directors of Federal Reserve Banks may be filled in the manner provided for the original selection of such directors, such appointees to hold office for the unexpired terms of their predecessors.